How many of you really know what a grand jury does? Answer, not many of you. Welcome into my state of mind. I am Dan York. You know who you are. We are in the midst of a lot of hullabaloo coming out of Washington today on the guilt complex I guess America is supposed to feel over what we did since 9/11. That is not my subject for today. I will have some thoughts on it at the end of the program, but know that that we're on it and we shall program to it. I haven't had a chance to read the report. It only came out around noontime today when Senator Dianne Feinstein made her presentation, and then John McCain did, and all that kind of thing. But the phones on WPRO on the radio from noon to 3 today were very, very busy with folks who had thoughts one way and the other about whether we should expose ourselves the way we have with this long-form mea culpa and more. So stay tuned for that as we go. In the meantime, I'm going to eliminate the rundown for those of you who watch the show on a nightly basis, and thank you for adding to the growing audience each and every night. You know that I hit 6 or 7 different items most nights, but tonight I'm going to pass on that because I think we need a comprehensive conversation on the legal system. After the stories coming out of Ferguson, Missouri, and Staten Island, New York, 2 separate stories that, although police and a black person are the commonality, they are very different in very many ways. I find it horrifying how little people really understand about grand juries. So I've got a great guest to talk about that. And what motivated me to do this was like a headline like this. Ed Fitzpatrick wrote this. Well, you know, he doesn't write the headline, he writes the columns, and you know, I'm a fan of Ed Fitzpatrick, but you know, the trial would have had value in Ferguson as if the grand jury had an option to do the greater good and give you a trial so that everyone would feel better. That's not their charge. Here's what CBS put together in terms of some basics on what a grand jury does and what it looks like and how it operates.
The fates of officers Darren Wilson and Daniel Pantaleo were decided by grand juries, a system enshrined in the Constitution, considered by the framers an important check on government power. But now there is growing criticism the government can hijack the system to get results it wants. A grand jury is significantly different from a regular jury in a trial. It doesn't decide guilt or innocence, only whether there's enough evidence to go to trial. It meets in secret. Prosecutors dictate what evidence and witnesses the jury sees. There's generally no judge or defense attorney.
And that's just some of the basics. Professor Andrew Horwitz is here from Roger Williams University. Thank you, sir, for coming.
My pleasure to be here.
You have experience as a public defender in Brooklyn, so you've seen some New York grand juries, haven't you?
Oh yes, quite a few.
Yeah, so we'll get to the New York case in a minute, but in general, do you commiserate with me as I talk to my viewers here tonight about how little most people know about this system?
Yeah, I agree with you that I think, well, very few people have actually ever been called upon to serve on a grand jury in comparison to the number of people who've actually been called to serve on a jury in a regular trial.
Right.
And there's not a lot of press coverage, generally speaking, about what goes on in a grand jury, largely because it goes on in secret.
Yeah. I've been troubled by the number of people dialing the radio show or just in conversation who talk about the role of a grand jury and what they should have done in terms of fairness to the greater good of the picture and da-da-da-da. And I guess we could break down the Ferguson and Staten Island cases separately, but in general, they're not charged with the bigger picture.
No, no. To the extent that there's criticism fairly being levied in what happened in Ferguson, that criticism belongs in the hands of the prosecutor who made a decision to put the matter in the grand jury, where under Missouri law, and this wouldn't be true in many jurisdictions, but under Missouri law, he had an option not to put the case before the grand jury, simply charge it out and have it go down its path toward a trial. But the fault certainly doesn't lie with the grand jurors in terms of they were not asked to perform a larger societal good. They were asked a very narrow question about whether there was, in their view, sufficient evidence to bind the case over for trial.
All right. So if I'm a law student at Roger Williams and I'm trying to figure out the difference between a jury and a grand jury, you explain it how?
So a grand jury is a proceeding. It is in our Constitution. It exists in every state and in the federal system. It was historically designed to be a check on governmental abuse of power. And it is designed to play a role at the charging stage. It is designed to have some arguably representative group of the citizenry get involved at the very beginning of a criminal case to make sure the government isn't overreaching when it decides to simply charge a case. That's a very, very different function from a jury presiding over a trial. Our jury trial system is adversarial in nature. Both sides are represented. Everything happens in open court. Constitutionally, it must happen in open court. It's there for the press to cover. It's there for everybody to see. Everything is subject to adversarial testing. The grand jury is a secret proceeding by design. It is a one-sided affair by design. The prosecutor is the only lawyer, generally speaking, in the room. The prosecutor makes decisions about what evidence to charge. The prosecutor generally goes into the grand jury with an agenda of knowing exactly what they want charged and getting an indictment by presenting the evidence accordingly.
And the old phrase, you could indict a ham sandwich, is true.
It absolutely is true. What's disturbing, I think, to some people about the way Ferguson was handled, and I think this is true in the Garner case, in the Staten Island case as well, if the prosecutor wanted to get an indictment in either of these cases, the prosecutor would have gotten an indictment. I'm not suggesting that they didn't. I'm not suggesting the opposite. But if they wanted to get an indictment, they could have gotten an indictment.
By the way, and we'll talk more about that case specifically in the next segment, but why the way they craft what evidence is presented to the grand jury.
Absolutely right. And in most states, there is no obligation whatsoever for the prosecutor to present exculpatory information to the grand jury.
Meaning?
Meaning evidence that suggests the person is not guilty of the crime. So if I represent a gentleman charged with an armed robbery, the prosecutor, even though I may have witnesses who I've sort of served up to the prosecution, maybe alibi witnesses saying the defendant was somewhere else at the time of the alleged robbery, they have absolutely no obligation to present that evidence to the grand jury. And in normal cases, they won't.
Grand juries sit for a while.
Yes.
They're not just one case at a time.
Well, there can be grand juries that are specially convened to hear a particular matter or conduct a particular investigation. Okay. But generally speaking, you're right.
And so they sit for how long a period of time? Months at a time sometimes?
Varies from state to state, but yes, weeks certainly, sometimes months. Do
they suffer from fatigue or disinterest?
I'm sure they do. I mean, I can tell you a little bit from my experience in New York. A defense lawyer in New York has a right, I should say a defendant has a right under New York law to testify in a grand jury that's investigating him as a suspect. That's not true in Rhode Island, it's not true in lots of other jurisdictions, but it's a statutory right in New York. So my experience that's direct with a grand jury would be representing a defendant in front of a grand jury. I'm not allowed to speak in the grand jury, but I'm allowed to be present while my client testifies. My sense and my experience there tells me that the grand jurors were so bored at the routine of being presented one-sided evidence and being asked to answer questions that really weren't questions at all, that when they finally had an opportunity to hear a different perspective, when they finally had the opportunity to hear from a defendant, they were quite excited about the prospect of being something other than a rubber stamp.
You're talking about both cases. Well, Ferguson, certainly they heard it from the police officer. A potential defendant. He wasn't a defendant quite yet.
A suspect, we should say, or a target of an investigation.
I don't know if Officer Pantaleo actually testified in the Staten Island case.
I'm not sure about that either, unfortunately.
Yeah. All right, but we'll talk about how that all works. So now you get a little bit of a broad view as to how the two systems are different. When we come back, we'll talk about each case, Ferguson and Staten Island. Stay with us. Welcome back. Professor Horwitz has been kind enough to spend some time with us here on the conversation about grand juries. I just think there's so many of us that just don't understand how this system works, and if you missed the first segment, check foxprovidence.com for an online version of the program so that you can take some notes. We were talking during the break, I've never been on a jury. I would love to be on a jury, grand jury or jury, but guys like us don't get on juries.
Never had that experience either.
Got an opinion on something, Dan? As a matter of fact, I make a living on that. Well, see you later. Bye-bye. In Ferguson, this particular prosecutor, as a matter of fact, Laura, throw me Bob McCullough there. One of the things that he had to say when he made that famous primetime presentation.
They discussed and debated the evidence among themselves before arriving at their collective decision. After their exhaustive review of the evidence, the grand jury deliberated over 2 days, making their final decision. They determined that no probable cause exists to file any charge against Officer Wilson and returned a no true bill on each of the 5 indictments.
One of the things that a lot of people criticized in the Ferguson case with Michael Brown's death and Darren Wilson, the officer, not being even charged, there was this notion of a data dump. The concept that he just threw the kitchen sink at the grand jury rather than picking and choosing with an objective in mind. True analysis that was the term data dump is accurate, do you think?
Yes. I mean, let me put a little spin on it.
Okay.
I do agree with that. This presentation was so unlike the vast majority of presentations to the grand jury. Again, normally, the prosecutor goes into the grand jury. They know exactly what charge they want the grand jury to vote out. They present the evidence accordingly, and then they essentially ask the grand jury to vote out that particular charge. Putting the best spin on this, the prosecutor had an agnostic approach, did a sort of massive data dump. One problem with that in front of a grand jury as compared to a jury is there is no lawyer there other than the prosecutor to tell these people what they should do. Here's what's important, here's why it's important, here's what it means. That's the sort of heart and soul of our adversarial system.
No charge
we
or
didn't have an
instruction.
adversarial
No
system.
charge or instruction to the grand jury.
Oh, there is an instruction.
There's an
They
instruction.
get instructed on what the law is
Okay.
with respect to the charge that they're being asked to consider.
All right, so, but after that, they're pretty much on their own.
Correct. There's not a legal argument being presented.
And I understand that they, if you take a look at some of the transcripts, I mean, they were pretty interactive, especially with Officer Wilson. And of course, they were, but it was an interesting ebb and flow in terms of what this prosecutor presented. He presented a lot of people who I guess he felt were more likely to have lied about what they saw with the shooting, and kind of built up toward what I think most people would say is a more credible line of witnesses. So there was a weave, a pattern.
There was
that
a
he
strategy.
Yes,
Yes.
there was a strategy. What do you think inevitably was, I mean, at the beginning and the end was his strategy? What do you think was going on there? Of course, you're one of many, many minds, so it's one man's opinion.
Yes, and I don't want to accuse him, because I don't think there's enough evidence to do this, of wanting a result of no true bill. I don't think there's enough evidence, at least not that I'm aware
And
of.
no true bill
no
means
true bill
we're
means
not
no
moving on.
charge.
That's it.
No charge, right. A true bill is an indictment, a charge. So I don't know that I could say, and I wouldn't say, that he had that strategy in mind. So giving him the benefit of the doubt, the strategy was, I think your term of data dump is accurate. Just let's throw it all out there and let them figure it out and let them take the responsibility for it.
The irony, I think, for the folks who wanted to see an indictment and the Brown lawyers and the like, in so many cases, lawyers will argue, or defense lawyers, or those who think they've been aggrieved in the process will say, all the information wasn't presented. In this particular case, they were oversold on the information. It's all circumstantial as to what you want, and it's all situational, isn't it, as to what benefits you?
Yes.
I mean, for those who thought there should have been an indictment, he could have carved a way through the evidence just to get the indictment, and then the jury trial would be a whole different ballgame.
Yes.
So in this case, he just kind of went, here's everything we could ever possibly know about this case. Good luck to you.
Right. Without the benefit of cross-examination, without the benefit of adversarial testing. I mean, my own view is not that he should have gone into the grand jury and sort of pushed through an indictment, which he could have. Under Missouri law, when he had the ability not to present this to the grand jury, but simply charge it and allow a public trial to take place, that, I think, would have been the better avenue. I think based on what we know today, it likely would have resulted in the same outcome.
Well, see, this is what goes, this is the big question. Is it the prosecutor's duty to quell a political storm and charge something that when he looks at the evidence that he's data dumping, he can't see any way near a conviction? And if there's no real feeling that there'll be a conviction, why put an officer through the exercise of having to defend himself on such, a controversial and life-changing charge, right? So
I get the question, but my answer to that is I think the public perception of the integrity of the system is really important. And And I think you had to know in this case that if it was presented to a grand jury and there was a vote of no true bill or no charge, that the public response would be exactly what it has been, which is this happened in secret, it was controlled by the prosecutor who's in bed with the police, they never wanted an indictment, they didn't present evidence fairly. I mean, this invited that response. Had there been a public trial, you'd have adversarial testing, the public would see through press coverage, if not camera coverage, at least written coverage, day by day, what the evidence is, what these people are saying, what the cross-examination revealed, and then there'd be argument at the end of it. And if there was a not guilty finding at the end, and again, based on what we know right now, it looks like that's probably what would have happened, there might have been a better sense of public sort of, a sense that the system acted with some integrity.
Yeah, I just don't know whether or not. Well, it's something you could have 12 beers and be at the bar arguing all day long in terms of whether the prosecutor has that larger responsibility or just the acute responsibility to measure what he thinks this case evidence will end up with. So it's
what troubles me about the framing of that question is that it's very one-sided, because we ask that question when the defendant is a police officer. We don't ask that question when it's the Central Park jogger case, right? We don't ask that question when there's a very high-profile murder and we want there to be a trial. And that's, to me, what's troubling about the grand jury presentation, particularly. I guess we're going to switch gears at some point to Staten Island,
yes.
But that this case is treated so differently because the defendant is a police officer is, I think, part of why there's such a public uproar.
all right. We are going to Staten Island next. Stay with us. And of course, you see protests over Staten Island, and I think I even surprised some people on the radio when I suggested that I saw these two cases as very different: Ferguson, Missouri, and Staten Island. And I think Mr. Garner, I think he got. I don't think he got justice necessarily in this particular indictment or this jury decision of no true bill in Staten Island. The video itself, ironically. No video in Ferguson, but every bit of testimony that you could possibly get from the grand jury proceeding. In Staten Island, no testimony offered, but a video that told the story.
Right.
Unbelievable, huh?
Yes, that was a shocking decision.
Shocking.
Yes, to me, yes, and
Yeah.
I think to many people. Because if you think about what the grand jury is asked to do, they're asked to determine whether there's probable cause to charge something. And even if you don't assume an intent to kill, and I don't assume that based on the video, how could that not at least be negligent, homicide, reckless, manslaughter?
Important for us to say, they had about a half a dozen options, from reckless endangerment at the beginning all the way to purposeful murder, correct?
Right. Yes.
And they didn't choose any option.
Zero. It's shocking, and to me, much more than in Ferguson, it reveals that there must have been a prosecutorial agenda here to not get an indictment out of this grand jury.
And what we don't see in the Staten Island case is a data dump.
Right.
So going back,
we don't know what happened.
Well,
there.
going back to your original conversation about how a prosecutor can direct a grand jury proceeding the way he or she wants it to go,
right.
That must have happened here, correct?
Absolutely. And I think what we've learned from this, at least my takeaway, one of them is, it's really inexcusable to allow a prosecutorial office to run a grand jury process when the defendant is a police officer in the department with which that prosecutorial office works on a daily basis. That has created a public sense that there is absolutely no hope for justice in these cases. And it's hard to argue with it when you see the video of Eric Garner and you find out that the grand jury voted not to file a single charge. Hard to argue about that.
Although, if you listen to my radio show, there are a lot of people that were making arguments that even the video showed that this guy walked into a situation that, the caveat emptor, a form of it anyway, guy on the street beware, as opposed to buyer beware. You mess around with the police officers, you don't put your hands behind your back when they're asking you to do so, you're taking your life in your hands. I don't know that that's the way we want the criminal justice system to work.
It isn't,
There's
in
no,
my view.
There's, you know, I'm not the conservative on many things, but common sense dictates that at least we should have seen the evidence. We'd understand what the chokehold is versus the pressure on the diaphragm versus his medical conditions, and we would have been able to see an argument as to how this death was actually caused. Yeah.
I think the other piece, and we haven't talked explicitly about race, but I think that case very explicitly raises the racial issue, because I think most people, I'll certainly say me, find it hard to imagine that a person who was not a person of color would have been treated in that same way by the police in that setting.
Moral of the story with these major cases in the grand jury system, is it healthy in America today? What do you think?
The grand jury system is not healthy. There's a very, very small slice of cases where the grand jury is having a meaningful impact.
Come back again. Thanks. You're very helpful.
My pleasure. I'd
Appreciate
love
it. All right. One more thing. Stay with us. So the nation's abuzz over the torture reports.
The 600-page summary will reveal disturbing details on CIA interrogation techniques at secret overseas prisons, so-called black sites. The torture included waterboarding, used against terror suspects in the years after September 11th. The report concludes the agency went beyond legal limits in interrogations. Techniques were not effective, and the agency lied to itself, Congress, and the White House about the effectiveness of the program in order to keep it going.
A Democratic report with a Republican response, making it a very political document. It feels like one big layout on the psychologist's couch and a guilt trip, too. Lots to talk about. We got to read it first before we finally decide. By the way, did you see what happened last night? Brown beat PC, and that puts us in a funny situation for URI in PC tomorrow night. Do we have any video of that? We're not using it because they didn't think I could fit this all in. But I'm just saying, it'll be a big game tomorrow night, and congratulations to Brown. PC's got to hold on. We'll talk more about it tomorrow. Vinny Paz tomorrow night. Bye.